Thanks for joining us. The Coalition of Political Parties, CUPP, is lamenting the appeal court's decision which sacked state and National Assembly lawmakers in Plateau, Abia, and Enugu states. In a statement on Sunday, CUPP expresses disappointment with the position of the Court of Appeal on electoral matters, which runs ultra-vires to that of the Supreme Court. CUPP is asking the National Assembly to commence without delay the amendment of Sections 233 of the 1999 Constitution as amended to extend jurisdiction for state and National Assembly election disputes to the Supreme Court. National Secretary of CUPP, Umeh, says the irreparable harm and loss of the lawmakers would have been remedied if there was a further provision to appeal to the Supreme Court. And reactions have continued to trail contradictions in electoral petition rulings from the Supreme Court of Nigeria and the Court of Appeal. The comments came after the Apex Court ruled on an electoral position against Caleb Muftang, the governor of Plateau State. In November, the Court of Appeal in Abuja ruled that Muftang did not qualify to run in the 2023 Plateau governorship election. The Court of Appeal cited Section 177 of the Constitution and held that the governor was not validly sponsored by the People's Democratic Party, PDP, for the election. The panel says that the PDP had violated a High Court order directing it to conduct a valid Congress in 17 local government areas of Plateau State. But in its ruling, the Supreme Court said the validity of nomination and sponsorship of a candidate is not a valid ground to void an election. The Supreme Court panel said the Court of Appeal had ruled on the primary election that produced Muftang, despite the issue being outside the jurisdiction of the court. The Supreme Court also stated that it had received evidence that the order of the Plateau High Court was not disobeyed by the PDP. The Court of Appeal had used similar rulings which the Supreme Court faulted to remove 16 duly elected National and State Assembly lawmakers who were members of the People's Democratic Party. What now is the fate of the lawmakers who have been sent packing on the legal grounds that have now been punctured by the Supreme Court? Is there a way to seek redress by these lawyers? Should the National Assembly amend the Electoral Act to allow state and National Assembly electoral cases to terminate at the Supreme Court? We have in the studios the National Secretary, Coalition of United Political Parties, CUPP, Umeh, who is in our off-site studio, and we also have a legal practitioner and a rights analyst, Tietie, in the studio here with me to help look at this developing story. The story is still developing, a lot of angst in the society, Frank, and I'd spoken to senior lawyers and the rest, you know, and other Nigerians. It's like there is no remedy. It's sine die, I mean, the matter.
Not really. The truth about it is that if we operate democracy with some measure of integrity, then there should be a remedy in terms of first, the realization that there's a grave injustice that has been done to the people of Plateau State whose mandates have actually been overtaken and disrupted and nearly destroyed by the Court of Appeal. Something very grave has happened. The expectation is that those who know they didn't win should first resign.
So you're talking of moral suasion.
Not
now,
necessarily,
right?
not necessarily. There's still a legal aspect to it. Those who are supposed to interpret the law, who knew what the law was, and apparently deliberately decided to rule in contradiction, head, right? Should also consider that if they don't remedy the situation, which appears to be constitutionally irredeemable, they ought to also resign. So I don't want to assume that it must be that these lawmakers must return. As it is, nothing can be done about the judgment of the Court of Appeal because it has a tone of constitutional finality. The judges themselves cannot do anything.
They cannot reverse.
They cannot
themselves.
review. You know,
they cannot review.
It's not done. It's not done. Our you know, constitution, our jurisprudence, and our legal practice as a country does not allow that. If there is a mistake where the court should write A and then it wrote B, that becomes a clerical error. The court can correct that, but not to correct the subject, the content of its judgment. It is practically impossible when the Constitution, it's not even the Electoral Act that dictates that. It's a constitutional provision that terminates all appeals with regards to National Assembly and State House of Assembly tribunal cases to the Court of Appeal. In this case, the Supreme Court was very woeful and apparently helpless when it was making that pronouncement. And you noticed the comments of Justice Ogunwumiju and Okoroenyang bemoaning heavily that the situation facing the people of Plateau and those persons who have suffered irreparably. I'm a bit you know, consoled by the fact that I read a statement by Jonah Jang that the People's Democratic Party is approaching the National Judicial Council. The expectation is that before the National Judicial Council does anything, wields the big stick, those all judicial officers who presided as members of that panel should, as a matter of honor, you know, tender their resignation letters as judicial officers in the Court of Appeal. They should, because they have breached a significant provision of the Code of Conduct for judicial officers, which means total loyalty to the Constitution, loyalty to the law, and having a reasonable understanding of the law, some measure of legal competence to preside. They have done serious damage. If you allow them to remain in the Court of Appeal, they'll do more damage. So there is, and then what is the impression any litigant will have if he has any case before them again and say, he will go with the impression that these guys in the Court of Appeal who started the panel, who did that damage in Plateau, they don't know the law. They're the ones who would whatever it is. So I think they should just take a bow and get out of the Court of Appeal.
All right, Frank, good submission there. Let's go to our offside studio where we have the Secretary of the Coalition of United Political Parties, CUPP, Peter Umeh. Thanks very much, Peter, for joining us. Now,
thank you for having me.
Yeah, we've just heard that there is no remedy. So, is CUPP not, you know, not necessarily crying wolf here? But once there's no remedy, there's no remedy.
What the CUPP was talking about is not just about, you know, seeking remedy alone. You know, the kind of rascality that took place with that judgment is heartbreaking. And so we are looking at, if you want to make a court a final, you know, destination for National Assembly and State Assembly issue, that court must be able to have that integrity that people could be very confident about and say whenever they go there, they will get justice. Because it didn't only happen in Plateau. We also have the same situation that was even very more diamond in Abia. I think Abia North or Abia South Senatorial District, where Dalit Nwogocha came from. He had a case that had led up to Supreme Court at the pre-election matter, and the same case removed him at the Court of Appeal. So what CUPP is looking at is the fact that if this thing has become like this, why not let's amend Section 2231E and Section 2461 and 3? And then, because these are issues of internal affairs or political property being misconstrued or misunderstood or misread by the court has really broken and devalued the growth of the political party over the years. Because if you look at Section 177C, that says that these candidates are not independent candidates. They are candidates carried on the shoulder of the political party, and their names have been submitted by the national headquarters. Even if you look at how parties operate, which is something we know, the state has very little role to play in nomination of political party candidates. The state has very little role for the Court of Appeal to remove over 24 members of the 4 members of lawmakers because they felt that this party had no structure and whatever reasons that was done, it is really heartbreaking. If you read Chidi Odinakalu's report, you will feel more pain because you know this was definitely deliberately done for political consideration, in trying to favor a set of people, and undermine the interest of the people who have elected these people into office. Because if the people continue to feel that our justice system cannot, deliver justice, if they continue to feel that electoral system will now, if after electing a person, the possibility of that person remaining for his tenure is now dependent on the decision of the court, then there will be fear in our electoral process, and it will encourage voter apathy. So we are calling for the amendment of section 223(1)(e) and section 246(1) and 3 of the Constitution, so that such thing does not occur again, so that people can have opportunity to take their case up to Supreme Court and then have the same opportunity to remedy whatever damage that must have been caused by lower court. Like my friend sitting in the studio said, those who have taken this decision to deprive the Plateau State people, the Abia State people, and with those people of their right of vote should immediately resign and tender apology to the Nigerian people, so that we can start to make the judiciary an institution that people are proud of, an institution that we can run after, an institution that we can believe in, an institution that can encourage Nigerians. Because if we have lost the lawmakers, if they are not working in line with the aspiration of Nigerians, if the executive is managing the laws in a way that does not protect the interests of Nigeria, and then we come to the judiciary where all our hopes have been buried, and then we are afraid, then that presents a great danger for our people.
Well, thank you very much, Peter. But we know we operate in a climate where people hardly resign, no matter how grievous the errors that they've committed. And this is an institution of great integrity. While they are even still there, even the president of the Court of Appeal, only they can say. Frank, let me come to you. Did the drafters of the Constitution envisage this kind of lacuna? And secondly, the Supreme Court, we know is being overburdened with cases ordinarily that should, terminate if you have maybe regional Supreme Courts and the rest. And if you have the lower appellate court that is up and doing, that, is peopled by men and women of integrity. Yes, there are some of them there. Some of us have families and friends amongst them, Don't you think that it will be too much of a burden on the Supreme Court again? Decentralization of the Supreme Court?
No, I don't think we should be calling for... Yes, there's need for us to look at the clogged dockets of the Supreme Court. There's no doubt about it. I think that the reforms should be in the area of decision-making and how judgments are written, and not these verbose and unnecessarily flamboyant judgments that tend to want to impress rather than dealing with the law and facts. But with regards to the finality of the Court of Appeal being the last bus stop for cases coming from the tribunal in National and State House of Assembly elections, ordinarily there shouldn't be nothing wrong with that. That's not the only point situation where the Court of Appeal serves as the final court. All the cases that emanate from the National Industrial Court also end at the Court of Appeal. But, for a matter that has to do with the political mandate of a people, does our Constitution think that it is proper that for the Court of Appeal to be the final court? This has just shown that it's not proper. Neither is it in the best interest of our political climate or our democracy. So there is urgent need for the amendment of section 246, subsection 3. Definitely the Court of Appeal should not be the final court with regards to such an important matter. But let me tell you, realizing that the Court of Appeal holds that sense and tone of finality with regards to the decision of such magnitude, those justices ought to have been extraordinarily circumspect. They're giving them time to realize that stare decisis, tamed by the decision that the Supreme Court has already decided, is something that is very important. This is, utterly embarrassing to the Nigerian judiciary at this moment. judges, justices of the Court of Appeal who knew the law, who knew that the Supreme Court had just decided in the cases of APM and President Tinubu, in the cases where it has, in not one, not two, not three, the number of cases that the Court of Appeal is aware of, that you cannot intervene in a pre-election matter which is not jurisdictional for a tribunal. And the Court of Appeal goes ahead to do this kind of thing. The idea is this: you can, make some persons lose their job and keep your job. If they don't resign, the National Judicial Council is usually very kind. It might just retire them. But won't they do the judiciary some honor and say, look, we goofed this time around? The People's Democratic Party is out there saying that the court has been compromised. What kind of thing is that? And you know what that means when the opposition party is saying the court has been compromised. But I'm happy, very happy that the Supreme Court didn't spare those justices of the Court of Appeal. It deprecated them and made them look at some persons who had an agenda, and they breached the Judicial Code of Conduct. And the National Judicial Council shouldn't take it lightly. I'm also very happy that the highly respected former Chief Justice of the Federation, Chief Justice of Nigeria, Walter Onnoghen, has been appointed by the body of benchers to take a look at some of these issues, or conflicting judgments, or deliberate, sabotage of the workings of Nigerian judiciary by lawyers, by senior advocates, and by judges. Is something that has caught the attention of the body of benchers, to the extent that we expect that Justice Walter Onnoghen, retired, would give some very important recommendations that will cure the situation. As it is now, it's very difficult. How do you resolve this? What is expected? Nothing more. And I wonder why Nigerians hardly take this thing seriously. If I have seen senior advocates being put on trial for not expressing the law correctly, I've seen lawyers facing disciplinary committee. But when it comes to judges, why should they remain? This is grave. If it had an opportunity of being corrected at the Court of Appeal, it's a different matter. We're talking about a political mandate. Nothing disrupts a democracy like this. Is it because the people are a bit, their understanding? Look at how embarrassing and how fallen, how hopeless they appear, just because of professional incompetence, legal incompetence of persons who ought to presumably know what the law is. This is supposed to be unacceptable by our standards.
Absolutely, absolutely. Let me come to you again, Secretary General of the Coalition of United Political Parties here in Nigeria, Peter Umeh. We hear that CUPP and other civil society groups are planning peaceful protests, besiege the Court of Appeal, the NJC, and the rest, mobilize the public against those justices in the Court of Appeal, that they must resign now. Is that?
No, yes, it's very important. Why these justices and other persons who find themselves in a place of authority take a lot of things for granted? It's because of the docility of the Nigerian electorate and the Nigerian citizens as at large. Because the most important thing is for you to work for the protection of our interests and for the protection of the Constitution of the Federal Republic of Nigeria. If you look at what they've done, it's talking about whether the incompetence. It's not about incompetence. A person walking on the street already know what the law is, as about sterile decisis, that these decisions have been reached by the Supreme Court on several occasions. Decisions have been taken in Peter Obi's case and versus the APC, saying that the internal affairs of political party remain within that political party, and members, and if you are not part of that, you cannot challenge such. So this decision to undermine, to disrespect and use the Constitution of Nigeria for political consideration or for benefit other than doing the right thing, it should be stopped. And Nigerians must rise to the occasion. We must be able to tell those handling our courts that enough is enough, and we cannot continue to display this kind of attitude and expect the international community to take us serious. If we lose every other thing, our court should not be something that will be taken away from us. The section is clear. The independence of the candidate is not in play. The candidate is riding on the shoulder of a political party. The political party has submitted the name of the candidate to INEC. INEC had already published that candidate's name. INEC is mandated by the Constitution to organize, to undertake and conduct elections, and also supervise. If you look at Section 221 223 to 229, and also, observe the affairs of the political party. If INEC had found nothing wrong with these processes, and these processes have been going, and nobody within the parties are challenging the decision of the party to submit this name, I do not know, because if you allow interference from inter-party point, then you find out that political parties who have this kind of judgment, or political parties who are in power, will now do a way to reduce the electoral victories of those in opposition. So it is key that we protect the mandate of multi-party democracy. It is key that we protect the sanctity of those who have gone to the ballot to cast their vote for a particular candidate. Because if you have truncated the mandate of freely giving to people at the post, and you are keeping your own job, and those one has no remedy on how to come back and start to act for 4 years, which their mandate is supposed to, to serve, then why are we there? There's no justice. And if there's for there to be justice, those who have taken this decision will honorably speak to Nigerians, maybe tomorrow morning, and tell them, look, we are sorry to undermine the Constitution. We are sorry to look the other way. We are sorry to do this. And for this, they should take precedence for international best practice and say, look, we are resigning our position, and we feel that those who are living back at the court will continue to do right to our people and do right to the mandate that has been given to our people. Because our democracy, I believe that our cases should not even be, those who are elected should not be determined by the court. I think they should be determined at the ballot. And that's why we're also calling of a lot of things that the Independent National Electoral Commission, all the kind of the review, the innovations that are brought in and they were throwing about the other way, because if you look at even within the guidelines of the commission, from clause 46 from clause 96, where they said they were going to use electronic transmission and failed, because if they were electronic digital footprint, today the argument would have been less than what we are suffering.
All right, Peter Umeh, let me quickly, Frank, the decision of the justices of the Court of Appeal who sat on those cases, can it very quickly capable of truncating democracy?
Not at all, not at all. And again, we should spare our democracy, spare Nigeria, spare the polity of all this idea of unnecessary protest and then heating up everything. The truth about it is that we must learn to respect our laws. Our laws are not perfect. These things happen to give us opportunity to improve on our laws. However, we know what the appropriate standards are. What has happened in Plateau, with regards to the decision of the Court of Appeal, particularly Plateau, simply shows that it's not enough to trust a three-man panel. That sometimes the Supreme Court, that's a famous statement that says that it is final not because it is infallible. It is infallible because it is final. So look, step a bit ahead. The mandate of the people is too important to leave in the hands of persons who do not actually possess what it takes to give finality to such kind of huge decisions. I think it's not enough to truncate democracy in any way. It doesn't go near there at all. Well, and there's no need for all those protests. They allow the NJC to deal with it, but the justices know what to do.
Well, every Nigerian has that civil liberty to do what they want to do. Thanks so very much, lawyer Frank Tietie, and Arise analyst, and the Secretary General of the Coalition of United Political Parties, Peter Umeh, for coming on Newsnight.